Good morning. Thank you for allowing us to present, and it's nice to see all of you. Some of you obviously know myself and probably Amanda much better. We're going to try and liven up the issue of insurance, if it's possible, and hopefully any issues that you have, you can raise after our talk or later when we're at lunch or this afternoon. We're happy to talk about more in detailed questions that you may have. When we decided to put this brief talk together, we've looked very carefully at factual experiences that we've had as the scheme has progressed over the years that we've run for 3 years. And it's amazing how there are patterns occurring, and they're the things that we've tried to identify during this very brief talk. We don't have enough time to go through a lot of what we've put on the slides because there's only half an hour and 15 minutes for questions. So we're going to whiz through and try and identify the important parts, and then hopefully you'll just come back and talk to us as and when you want to talk to us. Okay, what I've just said, please feel free to talk to us afterwards. We've got contact details there, so please do so as and when you feel as if you want to. The one thing we can't stop is litigation, and we have a lot of people saying, oh, it's never going to happen to me. But what you don't realise, and a lot of people don't realise, is that once you get a litigious person getting started, and particularly once they engage a lawyer, it's almost impossible once their costs run up for them to, I want to stop, or be able to stop because of their financial losses. And they continue and continue, and it's those costs, the litigation costs, is where really the insurance comes in. Obviously they pay out if there's a loss where there's some form of negligence, but the initial upfront cost is the cost of finding somebody to defend yourself, and if you're not insured, that's the money you have to find yourself. It's a safety net and a peace of mind, and if you're not a limited company, your assets, your own personal assets are at risk. And also, if your earnings, there can be attachments of earnings and various other methods for claimants, should they win, to actually obtain a form of financial settlement from you. And more frequently now in litigation, there is a bias towards payments being made over a certain period of time. These are normally set out by the court, and they can go on for years. And this can cause awful sorts of problems because firstly you've got a judgment against you, and secondly you've got a debt, an ongoing debt. So these are personal issues to think about. I mentioned it won't happen to me. You just can't stop people, basically. They decide to go ahead and they want to have some form of redress. And more commonly, it's the fact that they are financially struck for money, and that's what really forces them to go ahead. And with the no-win, no-fee option that's available, a lot of lawyers are willing to have a go because they know that people will basically pay up to get rid of the aggravation. And the other main point that we've identified is the requirement for public liability. This is another issue which has arisen over the last few years, particularly with the councils and certain marinas and other ports wanting normally 5 million as a minimum for public liability. Some policies call it third-party liability. I find that rather strange because anything's a third-party liability, but really it is a liability to the public generally. Right, move forward. Okay, and this is over to Amanda, just to give a brief run through on this, and I'll add anything in afterwards.
Yes. Don'ts, very important. We are unusual in that we do have legal experience. Karen is a qualified but non-practicing solicitor. And this experience is useful and transmittable and applies to all types of surveyors and their work. Now, the walkthrough survey, does anyone actually know what this is? I mean, we've heard about it a lot. This term is often brought up. And it does seem to be the result of time pressure from a client who will want a quick survey done. But inevitably in such a situation, things will get missed because you simply can't fit it all in. You can't squeeze a pint into a half-pint glass. I think you'll all agree. And, but if you've agreed to do it, you may be liable for any losses. So you just need to be a bit careful. And signing off unseen work. Now, if you have, if you've been, say, doing a valuation survey, the client may have a buyer lined up for a quick sell, and you've identified work that needs doing to the vessel, and your client gives his assurance or her assurance that it will be done. And then they then call you to say that it has been done, and that you can remove it from your report. Well, you can make the assumption that the client is telling the truth, and you do as you've been asked. But OMG, what a problem this can be. Never assume anything. Go and see it for yourself, or if you can't leave, or if you can't leave the report as it is. But anyway, we're going to talk more about reports in a little while. Now, over to Karen for favours, as it were.
I'm going to have to hold the microphone. So basically, through all my experience as a lawyer, a number of times I've come across people saying, I just did a favour for somebody. The biggest claim I ever saw was £84 million, which arose from a one-liner in an engineer's report doing a favour for somebody. And that was actually a building, though. So I always say to people, if somebody asks a favour outside your remit, just say no. It's a lovely word, just say no. And you don't even have to give an explanation, but I always would say, I'm sorry, but I'm unable to do that because it's not within my remit, but you can re-engage me to do it. And obviously, there'll be a charge to do it. In most cases, they won't want you to do it. And often the ones that want a favour done are the ones that know that there may be a problem. And that tends to arise every time I've seen a claim arising from a favour. Adjusting reports for third parties, Amanda's already mentioned. Don't adjust reports. We have claims arising where, in part from what Amanda has said, basically somebody's been told that something has been repaired, and they'd, in some cases, seen the repairs that were going to undertake the repairs, and the repairs have not been undertaken in the way that they should have been, but they've been signed off without being seen. And in any event, you should never adjust your report, because in most cases, those adjusted reports are going to be sent to the finance companies, either knowingly or unknowingly by yourselves. So one rule is don't adjust reports. And if you do, make a note in the report that you have adjusted a report, and that if the reader wishes to have further information on the adjustments, to come and speak with you. So it's absolutely open and clear what you've done to it.
And don't omit what you have not done from reports and the reasons why you have not done it. It's not necessarily a cause of a claim, but you may have a lack of defence if you have not clearly stated something you have not done. Possibly because you didn't have time or you couldn't gain access to the area in question. But for whatever reason, however seemingly irrelevant, just remember nothing is irrelevant when it comes to writing reports, but we are going to talk more about that.
Okay, the favourite issue for most insurers is terms and conditions. Here we're not talking about insurers specifically or their wants, but one thing is I would always say don't undertake work without your terms and conditions applying, and they can only apply if you've provided them to the third party and say that they're applying, or you've got them signed. It's always better to get them signed, but I know so many times terms and conditions can't be signed in time because there's always an urgent job that needs to be done, and it's not possible to get them signed because the party that you're working for is not able to sign them. But as long as you get your terms and conditions over and refer to them, in most cases, particularly in the UK, I'm talking about here, they can apply, and that will form a part of the contract, because you can have verbal contracts, obviously oral contracts, and contracts that are formed orally and with written information, and it's a matter of making sure that they have been sent to the party and that they have them before at least you produce your report or whatever you're producing. Okay, claims. I'm just going to whiz through these because there's a lot that I can talk about and Amanda can talk about, and we'll be here for the rest of the morning till lunch. Inaccessible areas, I think that's obvious. Make sure also they're stated quite clearly in your report if you can't access something and why, and that it's been agreed. I mean, it hasn't been agreed, it's been stated quite clearly, and if any other things need to be done by the purchaser or whoever's going to be actually looking at the vessel. Wooden vessels, absolute nightmare, complete nightmare for us when we're arranging people that do a lot of wooden work on wooden vessels. I can't say more than that, but often and not infrequently they've been pre-painted, and to such a degree that to actually see any areas that really do need repair and conditions of it is almost impossible. Osmosis, I won't say more than the fact obviously it exists and it's well-known process. Not stating what was not checked, it goes back to the report writing. It is really important that you state clearly all the time what you haven't checked, what you haven't done and why you haven't done it, and make sure it's quite clear, because that's one of your defences. If you don't do it, then there's a good chance that that will obviously provide ammunition for what would be the claimant. And this actually goes across the board, whether we're talking about pre-purchase surveys or any type of survey that you're doing. Always state quite clearly what has not been checked and what has not been done. And the other thing that we notice is not actually suggesting further investigations, just actually writing your report and not actually suggesting anything else should be done when it really is obvious that it should be checked. And when you're working with clients that may or may not know what they're actually involved in, even people that seem to be buying commercial vessels now that have no knowledge, it's important that you have clear suggestions, even if there's not recommendations, that things that should be checked. And the other thing where we find that claims arise from is the investigation or repair work, the timescales. This is causing a real problem for insurers at the moment. If there is not an indication that, of a time period when something should be investigated or checked, then that can give rise to a claim if there is loss arising from that. And valuations. This is another area which is causing a number of claims. Don't be swayed at all. People are being very persuasive as to the valuations that they want and they expect and why they need it. Just stand your ground, and even if you have constant correspondence, as we have seen in some cases, just make sure that you're happy with what you're using to actually confirm the value of whatever you're valuing, vessels or whatever, is correct, and that it's a true reflection, because the comeback will always be yourselves. Right, terms and conditions. I've just literally provided a list here of the types of terms and conditions. I know you can't always apply terms and conditions. Lots of conditions and terms in policies and in all sorts of contracts are there, but they know that they cannot actually bind you, but they put them in to put you off, basically, proceeding with any claim. I've mentioned about signing. There are a few clauses there. I haven't got time to go through them, but they should always be included in a contract. And there's many other standard clauses, but there's the limitations you need to look at: time restriction clauses, force majeure, jurisdiction, and your law and practice. And you should always separate out jurisdiction and law and practice. I always have two separate headings because you can't apply the actual jurisdiction in most cases. So make sure that it's a separate paragraph. That's what I always say. And one of the most important things is just to make sure although it doesn't come under terms and conditions, but it's a relevant place, I think, to put it here, is to make sure that you make immediate notes of any conversations and date and sign these notes. These are contemporaneous notes, so should there be a problem, you can use them as evidence. So it's always important that even if you haven't written back to confirm something that was done or wasn't done or should have been done, you've made a note of the time and date that you told somebody, whoever it is relevant to. Okay, very briefly, risk control, your report. Again, it's a very, very large area. Report writing is to some extent more important than your terms and conditions, because it's the way you write your reports that's going to prevent you from having some form of claim against yourselves. And it's the structure, the language and the content that is very important. I always say, well, we use a lot of templates and reminders in our business, and in litigation we have an awful lot normally, because when you're under stress, and particularly when you're a lawyer and you're desperate to get something out, you forget the most obvious, and that's when you get a claim as a lawyer, and that's when most professionals get a claim. So I say make sure you have templates which you tick off to make sure you've covered every aspect that you should be putting into your reports. And that really combines with the checklists. Again, it's when you're tired, you need your checklists. If you don't have them, that's the chance when you're going to actually forget something and not put it in the report. The others there are quite straightforward to write, obviously, a story of the events, and the contents must support the conclusion. I think the next one is probably obvious. And again, we've repeated timescales, as well as, I think the most obvious one at the bottom is the fact you're answerable to your client. Right, and over to Amanda, on this one for the first part.
Right, well, if you do have a claim, don't panic. Easy to say, but try not to. And as in any sort of car accident or anything, don't admit liability or infer it. Be very calm with your client. Try not to raise your voice. And in so doing, always be communicative, though. Always talk to them, because if you don't, that could be provocative. Always, especially if you're with us, let us know if something has arisen, or your insurer or whoever your broker is. And again, as Karen mentioned earlier, chronological summary of events is very, very important. And it helps everybody. It helps the insurers, it helps us, it helps you and the client in the end. And will make life just a lot simpler. And any documents, letters, any sort of correspondence, photographs, that also is terribly important, and to be sent to us or the insurers or whoever as soon as possible. Would you agree?
Absolutely, absolutely. Right, so we're going to whiz through the rest very quickly. These are the do's. I think they're obvious, really, but sometimes overlooked. Always be thorough. Write your report with care. Leave your report if you can do. The biggest mistakes are made because you read what you think you are seeing, but it's not actually there. Most people also don't look at their terms and conditions. You should look at them periodically to make sure that they actually do contain and cover what you are actually undertaking. Read any contracts that you sign. Don't waiver any rights, otherwise you've got a major problem. State your brief clearly. I've said again, provide T's and C's before commencing work. And I think one of the most important things is we say resist temptation. A number of times people have undertaken work and it's purely because of pressure on them. That's the time really to stand back and say no.
Yeah.
Thanks.
Yeah.
Right, and our disclaimer. We thought we'd make you laugh on that one.
That's very important.
Very important.
So you're ready for questions?
Yes, any questions? Oh, has that put you all off? Yes.
I don't think we can overemphasise enough in today's society how important it is to consider consider all of this care that you're talking about there. All too often, people are rushed headlong into the job and considering it from a technical point of view, and it's very important to consider all what goes before it and around it. You know, what you're saying here is very practical. And when you're talking about reports, if you're working on your own, there's not much you can do about it. But if you're working in an organisation, I would urge people to get someone else to read it as well, to help you out and question you and challenge you.
Well, through the whole insurance industry, I don't know whether you're aware, some people will be here, that there has to be sign off by superiors on absolutely every risk. And again, with lawyers, even when I was in my late 30s, nothing could go out without it being read and signed off by the partner. And it didn't matter what age you were, until you got to a certain stage, normally over 50, then you'd be allowed to sort of sign off, although that's changed over time because of pressures. But when I started, there was always a requirement, and any complex report had to be read by somebody else. So it's very important. So.
Well, can I just ask, sorry, Barry, just a quick question. Presumably, the most experienced and knowledgeable marine surveyor can still become victim of this. It doesn't matter how good you are.
Oh, no, age is
that's
no.
the point that I would want to stress to people, and we all right. Don't be complacent about what we do in the industry, and you know, you can dot the I's and cross the T's as thoroughly as you like, but you potentially still leave yourself open. It's just a way of life. Sorry, Barry. Didn't mean to cut across you, Barry. I'm sorry.
Barry Thompson, New Zealand. You end up with disclaimers. A lot of surveyors put an awful lot of disclaimers in their reports. Would you like to comment or say a little bit more? There's an awful lot of disclaimers. The only value really is to frighten off the client and hope he won't sue you. They would have no standing in court. Can you comment further on this?
Yes, you are correct in a certain sense that they are, and it depends because your disclaimer can be contradicted by the content of your report. When you get to court, as in most countries, you know, that are part of what was the Commonwealth or whatever, when they take a look at it, they will look at the whole content, sometimes the headings as well, depending on whether you've stated whether the headings are applicable or not. And then they may say, well, the content of the report will affect your disclaimer. So they look at it. I know it's very complicated. Contracts are one of the most complicated areas. That's and that is one of the major problems. It's understanding the case law and what we follow, and in various countries between sort of obviously Australia, etc., and we look at Canada, etc., and various countries. So yes, the disclaimer can be helpful to put people off, but equally, if it's written correctly and what is preceding it or post it is written correctly, so it doesn't either contradict it or modify it, then I think you're okay. It's important to have a disclaimer, I think, every time, but it depends what you've written in the rest of the document as to how it's actually read. Unless you put it, as a lot of insurers have what's called condition precedents, but this can't be per se because they would never accept it. I don't think it's ever been done as that. But condition precedent is something which applies as obviously a condition precedent, for example, before payment out of a claim. Sometimes they're very stringent, and sometimes they're not very stringent. Does that answer your question? I'm not sure I did. So.
Thank you very much, ladies. Can we